A will versus a revocable trust is probably the most common question we receive as estate planning attorneys. On the surface, they accomplish many of the same things. They both direct where your assets will go at death, how they will go at death, meaning will they go outright to an individual or maybe be held with some restrictions for a beneficiary, and also who's in charge of carrying out the wishes in both a will and a revocable trust. In a will, the person in charge is referred to as a personal representative, also known as an executor or administrator. That's all the same term. We refer to it as a personal representative. In a trust, the person in charge is referred to as a trustee. The biggest difference between the two is at death, how assets are passed. A last will and testament can only legally pass assets if the will is probated, which is a fancy legal term for opening an estate in the county of the person's residence at death. We are located in Marion County in Indianapolis, Indiana. So if you lived in Marion County at your death and had a last will and testament, we would present the will to the Marion County Probate Court. An estate would be opened for you. And at that point in time, the personal representative would have the legal authority to collect assets, pay bills, talk to creditors, and ultimately make distribution to the beneficiaries outlined in the will. Without that probate process, a last will and testament has no legal effect. On the flip side, a revocable trust, if properly funded, can transfer assets at death privately outside the probate process on the timeline as determined by the trustee. When I say properly funded, that means all roads ultimately lead through the revocable trust, whether that's retitling an asset to the revocable trust during the person's life, such as deeding a home or another property into the trust, or retitling an investment or a bank account, or listing the trust as a beneficiary on some sort of financial account, so that ultimately the trust is either the owner of an asset during life or at the person's death.